The Constitutional Court has confirmed that former Paralympian and murderer Oscar Pistorius is eligible for parole. In a brief ruling, the Constitutional Court says Pistorius' murder sentence started on 6 July 2016, meaning he had served half of his sentence, which was 13 years, by the date of 21 March 2023. Pistorius was found guilty of murdering his girlfriend, Reeva Steenkamp, in February of 2013. Correctional Services spokesperson Singabakho Nxumalo joins us now to give us the way forward. Mr. Nxumalo, thank you very much for your time. Let's begin with the back and forth, I think, if you will, based on the court case that ensued when Oscar Pistorius murdered Reeva Steenkamp. This was back in February of 2013. Was there confusion here about when he would be eligible for parole?
A very good morning, and thank you for having us. When Mr. Pistorius was sentenced even the first time, we were given that order by the High Court, giving us his name and the sentence, which was the first time capable homicide, and the sentence that he was to serve. And he started serving that. Placed out on correctional supervision, but then there were other appeal processes, which the Supreme Court then gave him 13 years and 5 months. We were again given that warrant of detention. And he started serving that sentence again. But Mr. Pistorius went back to court to say that particular warrant of detention did not include the previous term that he had served. Then the Supreme Court of Appeal gave us a new order, which now antedating to say the sentence we needed to start calculating from the 6th of July 2016. But then subsequent to that, there was another order issued by the Supreme Court of Appeal now giving us a different date. And we processed that. You will then remember that in March of 2023, on the 21st, there was a session to consider Mr. Pistorius in terms of parole, to say, is he suitable to be placed out? Then it transpired that there was another order received a day before, which was saying that he had not served the minimum detention period, which then caused the whole confusion. Then Mr. Pistorius took us to court again now, to the ConCourt, to say there was so much confusion, we needed clarity. And in our papers, we did not oppose that application, but of the view that let a competent court then give us a proper interpretation and clarify the matter. Hence, then yesterday, the order that we received now giving us those dates and also affirming that Mr. Pistorius has served the minimum detention period.
Yeah, there does seem to be a focus on your reliance on the Supreme Court of Appeal correspondence. And I'm going to call it correspondence because if I read an article on News 24, for example, they talk about how the parole authorities seemed to rely on a correspondence of a chief registrar at the Supreme Court of Appeal, and this registrar seemed to be saying that Mr. Pistorius had not yet qualified for parole when this matter came up in March. The question really here is about whether or not you were misled via that letter from the registrar at the Supreme Court.
Where we find ourselves is in a situation where the Criminal Procedure Act makes it very clear. It says Correctional Services, you cannot ignore a court order. It says Correctional Services, you cannot ignore a warrant of detention, meaning if a person is presented to you, even if you are overcrowded by whatever numbers, that person must be incarcerated. And if you receive an order saying that the prison term for this person has to be looked at it in this way, you cannot ignore that particular order. You are therefore now forced to say, let us go back and approach that court through the established channels to say, there seems to be a confusion here. Can we get clarity in terms of what is to happen? bearing in mind that the person who's also serving a sentence also has rights. That person can as well approach the court to say, I do feel that I'm being treated unfairly here. My rights are being trampled upon. Therefore, can clarity be provided? So we find ourselves in that situation, in the sense that we couldn't ignore these orders. And hence, even in our submission to the Constitutional Court, we said we were faced with these orders, or call them correspondences from the Supreme Court, either signed by the registrar or the presiding officer, but we could not ignore them. Hence, we therefore said to the Constitutional Court, can you kindly clarify what is to happen here, so that whatever action that we take is within the law, and we do not find ourselves in a situation where we've defied an order of the court.
Now that the clarity has been given by the Constitutional Court, and that court, by the way, basically puts matters to finality. My question to you, would Oscar Pistorius then, from here on, need to meet the parole board yet again before he is released?
Yes. Now, the process will mean that the parole board will need to convene and look into the profile of Mr. Oscar Pistorius and make a decision whether he's a candidate worthy to be placed out on parole. And once they've made that decision, they'll let us know and you'll communicate that. And because the reason why you cannot simply take this order and say, Mr. Pistorius, go home, is because it is only the parole board which has that authority, and it is only the parole board which can make that decision. Because what happened in the last sitting on the 21st of March, it gave him what we call a further profile, where it said, yes, we've seen you, we've gone through everything, but what we have here is an indication that you are yet to serve the minimum detention period. Therefore, we have to stay within a correctional facility until such time that you have met that particular requirement. But now things have changed. Hence, the parole board has to meet and then craft a way forward in terms of Mr. Pistorius' suitability to be placed out or to continue serving a sentence. But they will have to provide reasons whether he is worthy to be placed out or not.
Well, let's try and explore those processes that will determine whether he is worthy of being released. What is of utmost importance here is the victim-offender dialogue. Mr. Pistorius is not sitting in jail because he wanted to. He murdered someone. The family of Reeva Steenkamp, what have they had to say in the last few months? Because the understanding was that he even had to be moved to the Eastern Cape, which is closer to the Steenkamp family, so that there can be that dialogue. Are they satisfied after the talks?
Okay. The reason all the process that you mentioned had to take place was because of the orders that we had at the time and the understanding that come the 21st of March 2023, Mr. Pistorius would have served the minimum detention period, thus being eligible to be considered for parole placement. Then our process says that there ought to be victim-offender dialogue. Hence, he was moved to Gqeberha for that particular purpose. It happened. He was then moved back to Hosimamburu under a center at Asheville, where he then continued serving a sentence. But there were also other processes where now the victims of crime were then invited to make representations, of which they did. And then in his profile, there were also other reports that needed to be finalized and included in that. Hence, we call it an offender profile. It is that profile that gets to be submitted to the parole board, because the parole board is independent, so they are not privy to all these other things. They rely in that particular profile because it contains everything about the life of that particular inmate. So that profile is ready. So when the parole board meets again, they will have to go through that profile once more and decide if perhaps there is any amendments to be made, or they are satisfied with everything that is there, and then make a decision whether he is suitable to be placed out or not. If they feel that perhaps the victims must be called again for another hearing of hearings, they will decide on that. But they must always exercise, due care to the other people also involved, in a way that you ought to protect the process and make it a point that it is fair to everyone. But I will not want to talk for the parole board. It is a structure that has enough ammunition to look into matters and decide on what needs to happen. But as a department, our main task now is to take this order of the Constitutional Court, give it to Secretary of the Parole Board, let them decide on the date where they will convene and go through this particular profile.
Yeah, Mr. Nxumalo, I understand the the difficult position you may be, because we don't get to speak to the parole board. So you are that go-between. So I'm going to press you a little bit here on the detail.
Yeah.
When the victim-offender dialogue happened, are or were Reeva Steenkamp's parents satisfied that Oscar Pistorius is remorseful for what he did? Does he maintain that this was a mistake, or were there other ulterior motives that led to him to murder his girlfriend?
All what I can say to you is what was communicated to us by the lawyers representing the victims of crime. I cannot go into the other details, where they expressed satisfaction in the manner that the sitting was conducted and how the whole thing went about. That was forwarded to us even in writing. But what we then have to look at is to say, you've got different reports, you've got different participants, and in that collage of everything that goes into the profile, you cannot only pick one and say, because of this particular report, therefore the decision will rely on it. You ought to look at everything. Is this person ready to be placed out on parole? What is the risk or the danger of placing this person out? Will this person reoffend? Will this person adjust and start living as a law-abiding citizen? Placing this person out, will it therefore assist him, his family, the community, the society as a whole, moving forward? So there's a whole lot of things that they look at. Hence, we always explain when we have the victims of crime participating and other interested parties, where we say to them, say whatever that you need to say. You can even say it in written form or oral form, but please do bear in mind that there's a whole lot of other things that we look at. Hence, when a decision is taken, it is also communicated to all those who were involved. And it will be explained to them why did the parole board reach a particular decision. And then we'll move it, they will then take it forward. But we also understand that in almost 99 cases, the victims of crime will tell you that they will prefer that the sentenced person stays in prison forever, even if that person is not given a life sentence. And we explain to say, but ours is a correctional system where we say, let us mend this the person, let us correct what is wrong, prepare this person for life post-incarceration. Hence, we have these avenues such as the victim offender, where we say, let us bring the two of you together so that you can start finding ways of either forgiving each other or moving forward.
Exactly on that point. Exactly on that point, Mr. Nxumalo. Let me interject momentarily.
Yes.
The simple question, did the Steenkamps give the all clear that we have forgiven from our side, it's okay, he can be released out of prison?
I do not have that answer, and I will never have that answer. And I've explained that the only communication we received from the lawyers representing the victims of crime was that they were satisfied with how the process was handled. Whether they said, place this person out or not, I'm not privy to such detail. But as I've explained, there's quite a number of variables that the parole board will look at and then make a decision. The system is designed specifically for it to say, you ought to look at the journey that the person has traveled and see whether this person is ready to reintegrate back into society as a changed person as a different person.
All right. Finally, that parole board, do we know when it will likely convene?
The parole board will decide when it will be convening. For us is to give them the court order that we received only yesterday, and then they will work out the days within which they will go through this, whether it's a day's program or a number of days. But looking at the fact that they have dealt with this inmate previously, I don't think it's a process that will take more than a day, but I wouldn't want to prescribe what needs to happen. They will decide on that. But the moment they are ready, they will communicate to us, and once they've made a decision, they will also inform us.
Singabakho Nxumalo, let me thank you very much for your time, sir, spokesperson for the Correctional Services.